This material is made available to you by or on behalf of the University of Melbourne under Section 113P of the Copyright Act 1968. It may be subject to copyright. For more information, visit the University Copyright website.
Cases last week, and the tutors have asked them to prepare to do that again this evening after the lecture. Well, actually some from last week as well. So I'll let the tutors sort of run their own show. They've got different ways of doing it. But
when are the tubes? Are they after or before?
Yeah, straight after. Yeah. Right. So it's a bit of a long night, but it means everyone can be here.
So what time does that start?
It starts at 8. Sorry, at 7:15 it begins. We're 5:15 now. Yeah.
So half an hour or so earlier.
People can go and get a bite to eat or whatever they need to. Yeah, that'll be fine. And I'll just get one thing out of here. As I say, I'll just sit over there. Sounds like you guys have been absolutely snowed with work, huh?
Yeah.
I guess that's a good problem. I've left that thing behind. I'll make it up as I go. Well, I might begin if that suits you, and I'll just give that a clean. And I'm going to sneeze. No, one's enough. Oh, really? Yeah. Oh, okay. I'll leave it down there. Okay, guys, we might get started. We are in week 10, and clearly, yay, there's good and bad things about that. I will give a bit of information out on a discussion board about assignment 2. I've had a few little questions trickling in, so I've sort of postponed responding directly to individuals because there are so many of you. So I understand it is a reasonably challenging site that we've taken on this year. I think generally that's a good thing because it means you get to sort of stretch yourself a little bit with the various skills involved. But I do appreciate it's a bit of a tough one. But that's your background work. What we're doing here is going into some of the legal aspects, and we're very lucky to have with us today Andrew Walker. He's a barrister and vast experience across a number of areas, including urban planning, and has been a great supporter of this subject over many years. I hesitate to work that one out, actually, and there's no reflection on Andrew's dynamic and youthful approach to the law, or indeed urban planning. So I'll throw it over to Andrew, and you know what we're going to go through, and I'll introduce Andrew now. Cheers.
Right. I like to go in a fluid way, so if you have any questions along the way, just put your hand up, interrupt, and ask me a question, okay? And don't hesitate to do so. So today we'll be talking about two important aspects of the planning system. Firstly, extending permits, and then amending permits. But before we start, who can think of a reason why a permit might need to be extended or it might expire? What might happen along the way? You've got your planning permit. Any ideas?
Lack of funding.
Yeah, so to get the project up and running, developers typically need a certain percentage of their apartments to be sold or leased, or commitments to lease. Haven't got the funding, not ready to go. Any other reasons? Yeah, you might have problems getting supplies. Another factor might be, and this sort of leads to amending a planning permit, the market demand might change, or there mightn't be a market for one-bedroom apartments. You might decide, well, not selling these one-bedroom apartments, I need to change the design. I need to have some three-bedroom apartments. Have to amend the planning permit, delay, etc. All right. Now, I'm going to test your memory here. When you're applying for a permit, what are the two general reasons you might need a planning permit? The distinction you need to make in planning. I'll give you a hint. Development is one of the two things that might be a trigger for a planning permit. No? Use and development. Okay? Planning 101.
Makes me look good, guys.
They're the potential two triggers. You're sort of right, demolition's within, I was perhaps a bit mean there. Demolition is part of development, okay? And you're right, it is a separate permit trigger where there's a heritage overlay and some other certain circumstances. So they're the two things you need to consider when you're applying for a planning permit. What's the use? Does it need a planning permit? And what's the development? Does the development need a planning permit under the zone or overlay controls? So when we're looking at extending a planning permit, that's also one of the reasons why a planning permit might expire, because the development hasn't started within a certain time, or it hasn't been completed within a certain time. Or, if it's a use permit, the use hasn't started within a certain time, or if it started, the use has stopped for a certain time. So, they're the things you need to look at in determining whether a planning permit has expired or not. So, dealing with development first. The Act says a permit expires if the development doesn't start, or any stage of it doesn't start within the time specified in the permit. So get your planning permit, what do you need to do? Look at it, right? Look at it. What's the date I have to start the development by? What does the permit say? Then if it's a subdivision, the permit expires if the plan's not certified within 2 years of the date of the issue of the permit. Or if the development's not completed within the time specified in the permit, or if no time is specified within 2 years after the date of the issue of permit, or 5 years if it's a subdivision permit. So when you're advising a client, you've got them gone through all the hard work of getting a planning permit, don't let it expire, check these dates. Use. If it's a use permit, the use doesn't start within the time specified in the permit, no time specified within 2 years, the date the permit was issued, or if the use is discontinued for a period of 2 years. Then we've got permits which might be a use and a development permit. So again, same sort of concept. Development or any stage of it doesn't commence within the time specified, or if no time is specified within 2 years after the issue of the permit, or the use doesn't start within the time specified in the permit, or if no time is specified within 2 years after the completion of the permit, or the use is discontinued for a period of 2 years. Then there are special rules dealing with subdivisions. Okay, so very important you remember those things. Now, what does the term commencement mean? Sorry? Putting the fences up. Yeah, that's really testing the margins of what might be commencement. Sorry? Starting the development. So putting fences up might not actually be acting on the permit, it might just be preparing the site for the commencement or the start of development. Good trick, if your permit's about to expire because the works haven't commenced, start some works, right? Just to make sure that the permit hasn't lapsed. So the decisions, and these weren't on your list, so I don't expect you to have read them. There must be works necessarily involved in the development, so if I've got a planning permit to build a school, starting a development of the site for the purposes of construction of a dwelling doesn't count. It's got to be actually works related with the issue of the permit. But it's not necessary that they be substantial. So I've referred there to a case of Somerset and Morgan Property Developments Proprietary Limited and Melbourne City Council. Do you want to have a look up cases on Ostley? Nodding, Alan? Okay. So search Somerset and Morgan and you'll find it. So Somerset and Morgan, the project was a large project, a 17-storey building. The only works that were commenced were the partial demolition of the existing building and the putting in place 5 piles. So it was in Coot Island silt, so they needed to drill some piles for foundations for the building. But 5 piles was only about 2% of the total number that was needed to start the development. In fact, what the developer had done was really done the very bare minimum of works to start development and really hadn't substantially commenced, had really just done these works as a device to say that the permit hadn't expired. The tribunal accepted that. They said, well, look, that's the commencement of work, that's fine. So work had started. Another case, I lost that case, by the way, it was on the other side. But the next case is one I won, so I've given you a win and a loss. Next case is NBH Business Park. In that case, no buildings had been constructed, but earthworks had been undertaken to basically level the site. And again, some works for footings, digging holes, etc. had started. And again, the tribunal was satisfied that they were the commencement of works. And that was argued by the council in that case that you hadn't complied with the conditions of the permit before you started the works, so couldn't be commencement in those circumstances. And the reason was that you hadn't paid the client hadn't paid a landscape bond, and there were some other minor conditions that they hadn't complied with. Again, the tribunal said no, that's not relevant. And they made the analogy of going on a hike at Wilson's Prom, right? Start is when you take the first step on the walk. That's a start. That's enough for a start. So you can see a very low bar to establish commencement. But going back to your comment, sir, they made the comment that preparatory works for the hike, packing your tent and your pack before you set off on the walk, wouldn't constitute a start. So again, just putting up fences, you probably pushing it a little bit, I'd actually get in there and do some works, okay? So it's important to undertake some work, start some work so the permit hasn't expired. Can anyone tell me why it might be an issue if a permit has expired? Right? So in both of these cases, Somerset and Morgan and NBH Business Park, the council said no, we don't want the permit extended. Why do you think they might have done that? Yeah, what in particular? You're right, circumstances have changed, but what's a major change that might mean that you mightn't get a planning permit anymore? Sorry? Yeah. So the land might be rezoned, or a design and development overlay might be in place, putting in a height control. So in Somerset and Morgan, a planning scheme amendment had been put in place, which put a mandatory height control in place, which meant that the development was prohibited. And in NBH Business Park, the council wanted to rezone the land to residential from industrial. So it was a warehouse, permit for warehouses, not an appropriate use in a residential zone. Okay, so again, there might be very good reasons to not let your permit expire because circumstances have changed. All right. So when can you apply to extend a permit? Applications made under Section 69 of the Planning and Environment Act. The application must be made before the permit expires or within 6 months afterwards. Sorry about the typo there. Or if the development's commenced within 12 months after the date the permit has expired. Note, compliance with these time limits is mandatory. You can't get a dispensation or you can't get a waiver from complying with those dates. Right, so the tribunal has a general discretion to waive compliance with timelines, but the Act was amended to remove that provision specifically for extension applications. So another very good reason to keep on top of expiry dates for permits. They're valuable assets. Right, now I know you have read this one, or you should have read this one because I understand it was on your reading list. There are some guiding principles set out in Cantor and Murrindindi Shire Council. What are the general principles that apply to whether a permit should be extended? You want to tell me? I've mentioned one already, over there on the left. Change in circumstances. The planning scheme might have changed. Any other factors? Sorry? Yeah, close. Elaborate. Going back to the gentleman in my fellow follically challenged friend over there. Saying about finance and so forth. What else might have happened? Just elaborate on that. Yeah. There might be a good reason you haven't started. It might be because of finance. It might be because you have to get other consents from other bodies and they've been difficult. So you've had to get consent from Melbourne Water, or you've had to get some further plans approved by the council and the council's delayed in approving the plans. Basically, there might be a good reason for the delay. What else?
Direct from
Oh yes.
to the relevant bit.
Have you got a copy of Cantor with you?
It's on the LMS under the readings.
And it's neatly summarised in the summary of the case at page 287. So you don't have to go all the way to page whatever it is.
It's way back.
Yes.
It's a tough one to read, yeah.
So we've dealt with change of planning policy. Change of planning scheme might be relevant. Intervening circumstances. What do we want to discourage developers from doing? Just sitting on the permit, right? We don't want a developer just having a permit, not acting on it, really having no intention to act on it, and just the intention is to what's called warehouse it. Sell it off to another person, make a quick buck, move on. That's a factor against extending a planning permit. So if you've got evidence saying, look, I've been trying to get this permit up and running, haven't been able to get finance, council's been difficult, haven't been able to get approvals, that's a factor suggesting you're not warehousing a permit. Total elapse of time is also relevant. When was the permit granted? It was only granted 2 years ago. The 2-year period might not have been reasonable to get the development up and running in the first place. If that's the case, then that's a factor supporting the extension of the permit. Economic burden imposed on the permit holder, that's another factor we've discussed before. Found it difficult getting finance. It's very costly. Sometimes, for example, you might have to do a site clean-up to remove contamination, very expensive. That's a good reason for getting an extension. And finally, the prospects that you get a permit if you turned around tomorrow and lodged the same application. There's a bit of overlap there with whether the planning scheme has changed in the interim. So, they're all listed there. Cantor factors. So somewhat unusual in that the court went to the Supreme Court. Often these matters go to VCAT. Went to the Supreme Court. So the Supreme Court took the opportunity to set out the factors that are relevant in extending planning permits. And the tribunal, VCAT, has consistently applied, they're called the Cantor factors or the Cantor principles in determining whether a permit should be expired. So, how does that apply in practice? I've given you 3 examples there. Let's, I'll just ask you to, I'll tell you the facts and I'll ask you to consider which way you think the tribunal went. And if you think you need more information from me, just put up your hand and ask me to provide that information.
Give them a chance to cross-examine a barrister.
Yeah. Yeah. All right. So Somerset and Morgan. permit was issued in 1998, Melbourne City Council. It was issued at the direction of VCAT following a VCAT appeal, and the proposal was for a 17-storey building, so a substantial building. The permit said the developer had to commence development within 2 years of the date the permit issued, and then complete construction within 2 years of the date of commencement of construction. Okay, so basically 4 years maximum to complete the development. The council, however, granted one extension so that they had 3 years to commence the development. Now, as you've heard, the developer commenced construction, but in a very, say cynical, didn't really commence construction. They did legally commence construction, but hadn't substantially commenced construction. So they'd undertaken some demolition of the site, and they'd also put in the 5 piles, as I mentioned before, foundations for the building. I don't know the total height of the building, but 17-storey building, say an average of 3 metres per floor, 54 metre height, let's say, over 50 metre height. Meanwhile, after the permit was issued, the council advertised Amendment C20 to the Melbourne Planning Scheme, and it implemented a mandatory height of 14 metres. 14 metres. Mandatory, what does that mean? Does that mean can I get a permit to exceed that height control? No. So if the developer applied for a permit now, bad luck, can't have your 54 metre storey building, 14. Reinforces the importance of keeping permits valid, doesn't it? All right. Anything else you need to know? They'd just taken that sort of token commencement, so they'd undertaken... Yes. So they'd just undertaken some demolition and put in the 5 piles. That was it. Yep.
Reason for the extension? They don't, even if they're not taking council's approach,
Yeah.
they still have to
Like,
say
what does council say about that?
it can't be denied based on that, but they don't define.
They do have to say, look, provide an explanation why they need an extension. I'll tell you, I'm probably giving you the answer. What? I'm giving you all the facts. All right. What's it here? Your cross-examination was very successful. They said, look, 17-storey tower, we only got 2 years to start development. How can we possibly start and finish this development within 4 years? Any other questions? But what do you think? Do you think they should get an extension? Remember, it's not prohibited now. The council said, no, we're not going to give you an extension. We've changed the planning scheme. Development's no longer allowed under the planning scheme, so no extension. A 54 metre tower, 55 metre tower, contrary to the vision for this area. Yep. Yeah, they had all their plans who thinks they should get their extension? All right, a lot of undecideds, or a lot of people saying no extension, no extension. A lot of undecideds, I'd say about 50-50. 50-50 yes, no, 80% no decision. Just like a council sitting on the fence, no decision. The tribunal said the permit should be extended, right? So a huge relief for the developer because they would not feasibly been able to complete the development before the permit expired. So the tribunal said, look, 2 years, even 3 years with the council extending it by a year is just not enough time for a 17-storey development and project of this nature.
To support such an argument in the tribunal, would they have called on an expert in finance or property, or how do you substantiate such a claim? Because I've noticed that developers could really get their act together very quickly sometimes, should they need to.
Yep.
So how do you come through such a thing? I mean, it's not a court of law, but
Yeah, well, they didn't call any evidence apart from the company director. So the company called the company director to basically set out what the company director had done and said it was a huge problem to finish the development, and a town planner. But the tribunal's an expert tribunal, so the tribunal in this case sort of said, well, I know from my own experience that 2 years is not enough time. But you're right, Alan, ideally you would call evidence from financiers, that sort of stuff.
I suppose if the company director is bound by another set of guidelines around his role as director, so it's more serious to perjure himself or whatever than an ordinary person. Maybe that holds some weight.
All right, let's move to the next example.
They've been very soft up here.
Yeah. Particularly given I lost that case. The next case will deal with Turner and Baw Shire Council. So, in Turner and Baw Shire Council, the tribunal applied the Cantor principles. It was an application to extend a permit. It was basically a large supermarket development. In this case, the permit holder was applying to extend the permit, the commencement date for the starting of works under the permit. So the works they'd done, they had prepared plans for the upgrading of a road and had plans approved under the permit for those works. There was a heritage site, the Warrigal Milk Factory. They hadn't commenced demolition of the factory, but they had prepared a report to record the industrial history of the factory, and they'd removed some of the equipment from the existing buildings in preparation for demolition. They needed a number of approvals under other bits of legislation, so they had to buy some land from the council, they had to buy some land from the Crown. They got agreement in principle for the council and the Crown to sell land to them, but hadn't acted on that. They hadn't got any tenants. The permit stated that the development had to commence within 5 years of the date of the permit being issued. 5 years passed. So this was the first application to extend the permit. And that's also a relevant factor in the Cantor considerations. Has the permit been extended in the past? The council proposed the extension, saying the proposed development was contrary to the new urban design framework that had been introduced, in that it was an old school supermarket that didn't really fit in with the balance of the town and didn't have good pedestrian permeability and connectivity with the balance of the CBD. On the other hand, the permit holder said, look, this is a complex project. We had to do a number of things in the 5 years. We just haven't been able to do it. We had to do things like get a whole suite of plans approved, buy land from other authorities, and we just ran out of time. So, that's the background. Basically, in summary, the permit applicant saying, look, or permit holder saying, look, 5 years hasn't been enough time. The council saying, look, planning for the town's moved on and this proposal is not in accordance with our vision for Warragul. 5 years also being the period for commencement of the development. Yes. Yeah, that's what they said. They said, look, we had to buy land from the council. That's also taken time. We're not going to start the development until we've got all that finalised. Yeah. Any other questions? Yep. Urban Design Framework, I don't think had been incorporated into the scheme, but was in the process of being adopted by the council. And the council also called expert evidence from an urban designer who said the proposal was contrary to good urban design practice. There'd also been some guidelines introduced in the state planning policy framework about designing for activity centres, which reinforced the need to provide for connectivity and permeability of the site. Yeah. No, and they also didn't need going back to the gentleman up there, they didn't actually need a planning permit to remove that stuff from the diary. They could have done dairy, they could have done it anyway. So yeah, it wasn't considered to be commencement of the development. Anything else? Was there another question?
Why do you think council gave them a permit in the first place if it went against good urban design principles?
Yeah, that is a good question. I think part of it was that Warragul's a relatively small country town, and this landowner owned a valuable parcel, and the council was keen to see economic progress and saw this landowner as being able to get a new supermarket in the area and jazzing up the town. But in the intervening 5 years, things have moved on and they've seen that, well, look, this guy's not really serious about developing this site and we think we can do better. I think that's, in a nutshell, what happened. Yeah.
And the design predated the 5-year permit by another 3 years.
Sorry?
I just read it.
Oh.
The design for the site predated the permit by 3 years.
Yeah, yeah.
It's an 8-year-old
Yeah.
design, which means that it was very
Out of date, yeah.
So
Yeah, so I won't ask you what your opinion is.
So, do we know what Hobart Supermarket was?
No, that was the other thing. They couldn't say, look, we've got a Coles ready to take over.
So they haven't really
They hadn't got a tenant.
anything at all in any way.
In summary, yeah. Okay, yep.
With the land they were trying to acquire, that they were saying was taking a while, had they been trying to get it for 5 years, or was it
Yeah, they had, you know, it was a bit half-hearted, yeah. Couldn't really say they've been pursuing it vigorously. All right, you've probably cross-examined me into the answer there. Who thinks no permit extension? All right, permit extension? No one, okay. Well, you're right. No extension of the permit. Contrary to the Somerset and Morgan case, the tribunal said, look, 5 years was a reasonable time to start this development. And if you were serious about the development, you would have got a hell of a lot further than where you were now. You might have got Coles confirmed as a tenant. You would have bought the land. You would have commenced development. Really, you're just dithering around, and things have changed. Things have moved on. It's a bad design. And for that reason, we think it's a bad planning outcome that the permit be extended. All right? Yeah, well, one of them is warehousing. So, you know, one of his strategies might have been, well, I'll just keep the permit in place so that I can sell it to someone else. I also think it was a case of an inexperienced developer with a large project and just not really being on top of the application. You know, once you've got a permit, that's not the end of it. There's a hell of a lot of things to do afterwards. Getting the plans endorsed, complying with all the permit conditions. In this case, buying land from the council and the Crown, you know, and he really needed to be on top of it, and he wasn't. All right? So, any questions on extending planning permits? Yep.
So the council sets out principles. Would it be true to say that it's kind of, you know, some of those principles might carry more weight than others? Like
Yeah.
a financial case seems pretty compelling. Some sites, however, are really challenging to deal with, or is it just taken on balance where discretion is being exercised?
It's a weighing up of all the different factors. I think the reasonableness of the time period is perhaps more important than other factors. And I think it's also important if you have got a permit and it's got a time period which is reasonable, you've got to actually demonstrate you're acting on the permit, particularly in circumstances where the planning scheme has changed. I think if there's no change to the planning scheme, you're probably almost certainly going to get a planning permit, because if you applied for a new one, you'd get it because nothing's changed, right? And being pragmatic, it's a hell of a lot more efficient in terms of resourcing to extend a permit than start again.
You just used the word reasonable.
Yep.
Is that a particular test that could be applied?
No, it's
Or is it like the man on the train omnibus, or, you know, these sort of cases, or is that just, again, common sense?
it's really just common sense. So I think the Somerset case, you could clearly say that 2 years is not reasonable for a 17-storey tower proposal to get that up and running, even 3 years. 5 years is a fairly long period of time. All right? But most important thing is to avoid this argument by commencing. So, the other thing is, if you've commenced, I would also say it's easier to get a extension to complete the development, because you can say, well, look, I've commenced, I'm proceeding, I'm acting on the permit. What are the options? If commenced, the permit's expired, the site's just a bomb site. So you can say, well, look, I am actually commencing, surely it's better that the permit be extended so I can complete the development.
In such a case, if someone is incredibly slow, eventually enforcement action
Yeah.
be brought to bear to deal with the whole site.
Yeah, that's very tricky though. Yeah. Very tricky to get a developer to complete a development. Right? Okay. Amending planning permits. What's the first thing we might have to consider?
Just on a break, do you think we should take a little break?
Sure.
About now?
Yep.
Because I think there's a bit more time
Yeah.
in it, and rather than having a break,
Yeah.
just
Yep.
at this point. So,
All
shall
right.
we say like a 5-minute break, toilet, drink of water, whatever, stretch of the legs, just to find a strategic moment. Sorry to break
Yeah,
in.
no, it's
Andrew.
okay.
Yeah.
It's good.
And I'll stop that recording because it makes it easier for them. And we're recording in progress. Yep, all good.
Okay. So we've dealt with extending planning permits, amending planning permits. Why might we need to amend a planning permit? Give me some ideas. Put your hand up there, sir. No? Yep. Yes. Yep. So, yeah, no, it does happen. There might be a mandatory height control of 14 metres. Planning scheme amendment, suddenly it's discretionary. I think you've got your 14 metre development, you think, well, discretionary now, let's go for 20 metres. Sure. Sorry?
You could have land in Fisherman's Bend.
Yes. Yep. Yeah, don't get me started. No, it's Fisherman's Bend. That's why we're all so busy at the moment. Fisherman's Bend is about an 8-week planning panel process. I'm not involved in it, I'm doing everything else, but there's the Minister has a QC and 2 juniors. The Melbourne City Council has 2 junior barristers. The Port Phillip City Council has a solicitor advocate. A landowner consortium has 2 QCs and a junior. Yeah, it's quite extraordinary. So, and there are also other landowners who are represented. So, it's difficult to imagine how much is being spent on that in legal fees and town planning consultancy fees. But it's good for business. So, it's not such a bad thing after all. All right, yes? Any other reason? We've touched on it before. Yep.
You might want to maximise how many apartments you put into the building.
Sorry?
You might want to maximise how many apartments.
Yeah, exactly. So I've noticed in the last couple of years there's actually been a move to from 1-bedroom apartments to larger 2- and 3-bedroom apartments. So market forces mean you might have to change your proposal to respond to market demand. The other thing as well is when you're doing your detailed design, you often find that things need tweaks here and there. Okay, so there are a whole variety of reasons you might need to amend a planning permit. 4 means we can do it. 4 major means. First, secondary consent. I'll explain what that means in a little while. Second, under Section 72 of the Planning Act, Planning Environment Act. Third, under Section 87, capital A of the Planning and Environment Act. And fourth, under Section 87. I've just put in there Section 71, that's a slip rule. So if there's a typo or some mistake in the permit, it can be fixed under Section 71. We won't really deal with that, we'll deal with the 4 principal means. What's the first thing you might need to consider? It is, do I actually need to amend the planning permit? So, permits are generally issued on the basis that the development's generally in accordance with the endorsed plans. What does that mean, generally in accordance? There is some flexibility in the phrase generally in accordance with. So, it's discussed in that case there. It may be that you don't actually need an amendment if the change is fairly minor and really makes little or no difference. So a couple of centimetres here and there, for example. But let's assume you do need to amend the plans or need the planning permit. Let's deal with secondary consent first. So it's the first means of changing or amending a planning permit. There's a limit. It's only plans, drawings and other documents that can be amended under the secondary consent mechanism. When you're acting for a developer, make sure your permit has this condition in it or something similar. Because you can't use the secondary consent mechanism unless there is a condition in the planning permit, something like that. No condition to that effect, no power to amend under the secondary consent mechanism. So the secondary consent mechanism is amending plans under a condition of the permit. Right? So you apply to the responsible authority to amend the planning permit. Now, let's just go back a step. I'm applying for a planning permit and it causes material detriment. What has to happen? Advertising, notice. Yep. What do you think might be a benefit of using this mechanism? So you're not applying, it's a different process to applying for a planning permit. You're applying to the responsible authority that plans be amended under a condition of the permit. What's an advantage, do you think, in comparison to applying for a new permit? Yeah, big advantage if you're the permit holder. Remember, you apply for a planning permit, has to go notified to neighbours. Neighbours have the right to object. Neighbours have the right to appeal to VCAT if they're not happy with the council's decision, or if you get a notice of decision from the council that a permit be issued, they have the right to, if you get a notice of decision from the council that a permit should be issued, they have the right to participate in that hearing. secondary consent mechanism, bad luck. No notice given, no right for third parties to get involved. Big advantage for a permit holder. So, West Point. Secondary consent changes do not attract third participation. That should read or rights of review. As a matter of practice, councils shouldn't even give third party notice of secondary consent amendments. Sometimes they do, but as a matter of practice they shouldn't. And council really shouldn't be informed by objections from the objectors, and that's member Hadra Giorgio in Ostcorp Group Limited in Mount Monash. So yeah, big advantage.
So, Andrew, the form of the application doesn't really invoke the Act.
No,
So,
council.
does that not mean that councils would do quite unusual things
Yeah.
in their system?
They generally have a form that you fill in. So most councils will have a form. Are you applying for, you know, to amend your plans under secondary consent?
But there's no time limits.
No time limits. There is a right to appeal if the council hasn't decided the application within a reasonable time. There's no time limit. So, is the right to amend plans, documents under the secondary consent mechanism unlimited? Or what are the limits on the secondary consent power? You read West Point?
There is a copy, but I didn't ask them to read it.
Oh, okay. All right. Anyone read it? Okay. Yep. That's a fair summary. Yeah. So, because there's no notice given, there's a limit to what you can do under the secondary consent mechanism. Wouldn't be fair, for example, if someone had objected, a permit's issued, the objector hasn't taken it to VCAT because they're happy with the end result, they're happy with the permit conditions, and then the permit holder puts in amended plans which increase the height of the development or have some adverse effect on the objector. So there's a limit to what can be done under the secondary consent mechanism. So the tribunal has developed a set of rules known as the West Point criteria. So if you're a council officer, you'll need to know how to apply these West Point criteria because many applications to amend plans using the secondary consent mechanism will come under your desk, or onto your desk, not under your desk, unless it's in a brown paper envelope. Also, if you're acting for developers, you also need to know what these parameters are so you can, you know, try and get plans amended under the secondary consent mechanism. So, the test is set out there. There are a series of tests. Doesn't result in a transformation of the proposal. So it's more than an amendment. Doesn't authorise something for which primary consent is required under the planning scheme. So the permit might authorise a childcare centre. Can't approve amended plans which would permit a retirement village. Different permit trigger. Permit authorises X, Y, Z. Plans have to relate to X, Y, Z. You can't add A, B, C. It's of no consequence having regard to the purpose of the planning control under which the permit was granted. And what's really meant by that is, for example, the permit might have it might be a demolition permit under a heritage overlay. So the heritage overlay and heritage considerations are directly relevant to the issue of the permit. They're a key issue in the case. Can't then, and let's assume that the permit authorised only the demolition of the rear part of the building, couldn't then put in amended plans and have the whole demolition of the demolition of the whole of the building approved. Also, planning permit conditions often govern the overall height of a building, side setbacks, changes to the overall height or reduction in setbacks often are of consequence, having regard to the permit triggers. Perhaps the best way to explain it is to go through some of the examples. It's not really the way the test is expressed, but just going back to your point over there, it's really about whether would the change change the parameters of the permit, so add something additional, or would they have a significant impact on another party? So if you're reducing setbacks or you're increasing height, for example, no doubt it would have an adverse impact on objectors and adjacent parties. And it's not contrary to a specific requirement as distinct from an authorisation in the permit, which itself cannot be altered by consent. And perhaps again we'll just go to an example to explain how that works. Okay, so they're the so-called West Point criteria, and they place limits on what can be done.
Sort of thing that I find a very attractive prospect to put in an exam. Amongst other things.
Thanks, Alan. So, it's worth reading West Point. West Point said, you can see you're listening now. West Point was a case about the former Tip Top Bakery site in East Brunswick. It was a large development, series of buildings 3 to 7 stories in height. Large number of dwellings, 181 dwellings. What the permit applicant sought to do was to amend the number of dwellings or increase the number of dwellings from 181 to 237. So significant increase. But the permit holder also did not propose to change the building envelope in any significant way. So the 237 dwellings were basically within the confines of the existing building envelope. The tribunal, I'm sorry, I should also say that the number of car parking spaces was increased from 9 to 336 spaces, but the car parking waiver under, who can tell me what clause? 52.06. Car parking waiver under clause 52.06 was increased from 117 to 220. Tribunal said, fine, you can use the secondary consent mechanism to approve that development. So you can see it's quite a substantial change, but the key was the actual building envelope wasn't significantly changed, very minor changes. The tribunal said there's really no impacts from the increased number of dwellings. The intensity of use of the site was really not in dispute. In the council officer's assessment of the application, really the only possible detriment was from traffic and parking, and the permit applicant led evidence from a traffic engineer basically saying the impact from a traffic perspective was minimal, and the change would really perhaps be a slight oversupply of on-street car parking to a slight undersupply. And again, the traffic waiver proposed was really of no consequence having regard to the terms of the permit itself and the permit triggers and the council officer's assessment of them. Okay. So there have been quite a number of tribunal decisions dealing with secondary consent where this sort of change in the mix of apartments, changes in the car parking supply has been approved under the secondary consent mechanism, even though on one view it's actually, it does have a reasonably significant impact, particularly in planning cases where objectors often are particularly concerned about traffic and car parking. But nevertheless, that's where it stands. All right. Cook, is that on your reading list, Alan? No.
West Point or the
Cook. Cook.
No.
No. Okay. Next year.
Yes, I might be starting to overload it a bit. I'll put it up.
I just want, this case is a demonstration of limits. Okay, so after me describing West Point to you, you might think, well, there are no limits to secondary consent. Cook is an example of a limit, yes? Yeah, the tribunal also looked at that and they said, look, the internal amenity is still satisfactory. Now, also bear in mind that West Point was some time ago. When was it? 2011, I think. Is that right? 2006. Yep.
You've got the wrong case listed on the slide. That's the Shitty West Point Corporation versus Moreland City Council.
Moreland, you're right.
2005 VCAT 1049.
Yeah.
That's for the company going to 2017, the internal management.
So I will go back to West Point. Yeah. West Point did discuss internal amenity. Thanks for picking that up. Bear in mind, West Point was before there was a... Internal amenity is an issue that's really been front and centre in the last 5 years. Before that, the tribunal didn't really look at it in detail. So I think it's fair to say in West Point, although the tribunal considered internal amenity was okay, it didn't really look at the issue in the terms that the tribunal might today. Okay? Does that answer your question? So Cook and Mornington Peninsula Shire Council. Just go back a step. Yeah, apologies. The West Point case is not correctly cited in these slides. I'm sorry about that, but it is in your notes. Yep.
When they look at the tribunal, the many tribunal decisions, we'll take them straight out.
Yep. All right. So Cook and Mornington Peninsula Shire Council, what happened in this case was you've come across planning permits, and traditionally there's condition 1 saying before the use and development commences, amended plans must be endorsed, which show A, the height reduced by 5 metres, B, the setback on the western elevation increased from 1 metre to 2 metres, C, D, E, etc., requiring certain changes. In Cook and Mornington Peninsula Shire Council, basically the council approved a change to the endorsed plans which contravened one of those condition 1 requirements. And also after a adjacent landowner had been involved in the tribunal process and specifically required that condition to be included. What the tribunal said was, well, going back to the West Point criteria, that is contrary to a specific requirement of the permit, and it's also of consequence given that that condition was imposed as a result of the tribunal decision and submissions made by an objector. Okay, so there are limits on the ability to use secondary consent, particularly when it's a condition 1A, B, C, D, etc. requirement, imposing a specific requirement on the amended plans. Okay, so there are limits. And again, if you're a council officer, I would be very reluctant to use the secondary consent mechanism to approve anything that would increase material detriment, and in particular, that increases the building envelope of a particular proposal. Okay? But room for debate here. There are no hard and fast rules, so these West Point criteria are quite difficult to apply in practice. Right, but have a look at Cook and Mornington Peninsula Shire Council. It's a word of warning about the limits on secondary consent, and the council in that case got wrapped over the knuckles, obviously, for approving a proposal which was contrary to the specific permit requirements. Okay? Amendments of permits. Second mechanism under Section 72 of the Planning and Environment Act. Now, again, you apply to a responsible authority. It's a broad power, much broader than the secondary consent mechanism, but it's not unlimited. And it's treated as if it's a new application for permit and the same process is followed. Right, so disadvantage compared to the secondary consent mechanism, notice is given, objectors have the right to object, objectors have the right to appeal to VCAT or participate in any VCAT hearing. So if you're a developer, you want to use the secondary consent mechanism if you can. Australian Slate-Crete Supplies, anyone read that? What did the tribunal say about the limits of the power under Section 72? Someone tell me? Is it unlimited? No? What is it then? How is it limited? Transformation, right? tribunal said you can use it to amend a permit and the scope of the power is wide, but you can't use it to transform the permit. So, Australian Slate Crete Supplies applied the Supreme Court case known as Addicote and Fox No. 2. Changes made may be considerable without necessarily bringing it about that the permit granted is a different as opposed to a modified permit. So for a completely new or unrelated use or development, the proper course is to apply for a new permit rather than to apply to amend an existing permit. Now, the benefit of applying for an amended permit is that you've basically got the existing permit locked in. So there can't be a debate about whether the grant of the existing permit was appropriate or not. Instead, the debate is limited to what's the consequence of the amendment. So the scope of things an issue is limited. So I've got a case next week where the permit applicant has a permit for a 7-storey development, and they've gone back to amend the permit to add an extra storey, right? Just squeeze a little bit more out of the site. I am acting for the responsible authority, the Stonnington City Council. I can't turn up to the tribunal and say, look, the whole development's terrible. Permit should never have issued in the first place. It's totally contrary to chapel revision. Start again. All I can argue about is the merit of the additional storey and whether the additional storey is contrary to the provisions of the Stonnington planning scheme. Right? So for a permit applicant or permit holder, it's advantageous to apply under Section 72 rather than applying for a totally new permit. Okay? Australian Slate Crete Supplies says, look, there are limits to that. Although the scope under Section 72 is wide, can't approve a permit that would amount to a transformation. I'll come back in a little bit to explain. I'll give you a case example of an instance where the tribunal said an application is a transformation. Right? So that's Section 72. Treat it as a new permit, have to start again. Advertised, rise for objectors to object and then go to VCAT. Any questions on Section 72? No? Yep.
If you get an amended permit, does that extinguish the original permit?
Yes. Well, it doesn't extinguish it, but the...
Well, that's part of the permit. I mean, you can't. So actually, I'll go back to the old.
You have to apply to amend it back. Yeah.
So just worth noting that it's not as simple as it might seem. You can flip the flop.
No. Yeah.
So how much permit is associated with it.
Yeah. Now, I'll come back to my case next week later, but interestingly, there's a further complication to my case. Yep.
Sorry, can I just talk about this section? So if I incorporate, if I have a permit and then as a landowner and then someone else, a developer, also puts a permit on this site, hypothetically, if my husband ran 2
Oh, they're both valid. So there can be more than one permit in place for the site. Yep. And who can apply for a planning permit? Anyone, yes. Just checking. Yeah, so anyone can apply for a planning permit, the landowner or any other entity with the consent, or you don't actually need the consent of the landowner, you just need to notify the landowner. Right? So now we're going to move on to the third and fourth mechanism, whereby planning permits can be amended. Section 87A and Section 87. So go straight to VCAT, don't apply to the responsible authority. So there are two types under Section 87A. You can only do that if it's a permit issued at the direction of VCAT. So it's similar to Section 72. So if you've got a permit that's been directed to be issued by VCAT, you've got a choice. You can apply under Section 87A. You can also apply under Section 72, or you can do both. And there's also a power under Section 87. And that's really directed at addressing procedural irregularities, to use the legal term, or stuff-ups, to use the non-legal term. Okay, Section 87, dealing with stuff-ups. So there are a number of grounds on which a application under Section 87 can be made. Material misstatement or concealment of fact in relation to the application for the permit. The dodgy developer clause, right? Substantial failure to comply with the conditions of the permit. The second dodgy developer clause. Any material mistake in relation to the grant of the permit. The dodgy council clause. Any material change of circumstances which has occurred since the grant of the permit. I can't think of anything dodgy to say about that. Any failure to give notice in accordance with this Act, or any failure to comply with Section 55, 61.2 or 62.1, and that deals with referral authorities and the like. So basically some sort of stuff-ups occurred. Third parties have the right to cancel a permit under Section 87 if there was a failure to give proper notice. So there's a process whereby objectors who weren't given notice can challenge the issue of the permit. And that's really to deal with a situation where the responsible authority stuffs up and fails to give notice. When do you have to give notice if you're a responsible authority? Have they done this, Alan? Should they notice? Yeah, okay. I'm going to pick someone out. I'm going to put their hand up. When do you give notice if you're a responsible authority? Right. 52. Doing that from memory. 52. 52 of the Act. Yep. Material detriment. Yeah. So I better get the Act myself just to make sure. responsible authority has to give notice to adjacent landowners unless satisfied there's no material detriment, and give notice to anyone else who might suffer material detriment. Okay? Sometimes the responsible authority gets that wrong. Doesn't give notice. So there's a process for cancelling permits, right? If you're a responsible authority, if in doubt, give notice. Otherwise you run the risk of an application under Section 87. I'll just give an example, right? It's my own house, actually. My previous house, I had this madcap idea of constructing a cellar in the back garden, right? So got an excavator in, heritage overlay, 1960s carport in the back corner, house, dwelling here. Neighbour, something like that. So I had to demolish the existing carport, dig a big hole, then put a new shed over the top, trapdoor, voila. Do I need a planning permit for that? Heritage overlay residential 1 zone. Well, neighbourhood residential zone now. Yes, I do need a permit. Heritage overlay. And it's also less than 300 square metres. So I should have told you that as well, but I thought the heritage overlay was enough. So I need a planning permit to demolish, construct. What do you think? Think these guys should be given notice? Yes? Okay. Why? Yep. And? Yes. In terms of how? Planning issue, not structural. Doesn't it depend on whether the new shed is bigger than the old shed? Also heritage considerations, maybe if you could see it from the street, would also be relevant. Okay. Anyway, the tribunals, not the tribunal, the good old Darebin City Council decided not to give notice to my neighbours, right? So they formed the view that no material detriment. The new shed was smaller than the old shed, and there was a gate across there, so difficult to see the new shed from the street. Personally, I think the Darebin City Council went out on a bit of a limb. So I agree with you, sir, that they probably should have given notice to my next door neighbours, but they didn't. So I got my planning permit, happy days, in with the excavator. The advantage, of course, is that no notice, I get my planning permit very quickly, as opposed to potentially notice, appeal, notice, objections, notice of decision, potential for the neighbour to object. What's the first thing you should do, though, as a permit applicant in this scenario? Any ideas? Yes, spot on. Who said that? Yeah, spot on. Talk to your neighbour. Amazing how many disputes are avoided by just talking to people and telling them, look, I'm going to apply for a planning permit. I'll show you the plans when I get them prepared. Let's have a coffee, let's have a chat about it. I'm happy to listen to anything you might say. It might be that they say, look, happy, or I'm happy if you do this, make a small amendment, and they don't object, you might get your permit much more quickly. Okay? So, Section 87. Not given notice, there's a right to apply to cancel the permit under Section 87. Also, those other circumstances referred to there. Responsible authority, referral authority, the owner or occupier of land may also apply under Section 87. If you're an applicant, you've got to lodge your application as soon as possible. Can anyone tell me why that might be? Yep. There's a public policy reason. Planning permit is a valuable property right. Okay? And what you're essentially trying to do by applying under Section 87 is challenging that right, creating uncertainty about the validity of a planning permit. And it would be pretty unfair, wouldn't it, if you've had a planning permit, you've not actually started development, but you've had it for a year and a half, you've had plans endorsed, you've engaged architects, you've engaged town planners, you spent a hell of a lot of money, and then a year and a half down the track, someone next door says, look, sorry, I want to challenge the permit. So there's a public policy reason to the effect that if a permit's challenged, there's an onus on an objector to apply under Section 87 as soon as possible. Also, the power can only be exercised in the case of a development before completion or before the permit is substantially carried out or at any time if the permit relates to the use of the land. And again, that's for fairness reasons. If you've seen a development start next door and let the development proceed and you haven't done anything to try and stop it, it's a bit unfair for then that person to turn around and say, look, I want the permit cancelled, in circumstances where the landowner has spent a hell of a lot of money acting on the permit. Right, any questions on Section 87? So it's the process whereby objectors, third parties, can apply to cancel the permit, but they have to apply to cancel the permit as soon as practicable. Section 87A. That's an application, again, straight to the tribunal. The powers, again, wide, so similar to the power under Section 72, if not the same. But there are limits. For example, where there's been a previous VCAT decision regarding the development of a particular site, or where there's been a mediation where parties have agreed to a permit issuing on certain conditions. So it includes the power to intensify a prohibited use or issue a permit which exceeds the mandatory height control. So in Caden High Street development in Darebin, the developer obtained a permit to develop land in High Street, Preston. Like the case I'm doing next week, the developer sought to squeeze a little bit more out of the site and applied under Section 87A for an extra story to bring the maximum height to 21 metres. Meanwhile, the design and development overlay had been implemented, which introduced a mandatory 20-metre height control, so 6 stories. The tribunal determined that it could issue a permit for the amended development, notwithstanding that it didn't comply with the new design and development overlay. So interesting, isn't it? And it basically determined that the proposal was acceptable. And in particular, it achieved the design objectives of the new design and development overlay and otherwise met the strategic intent and requirements of the scheme. Probably a bit of an unusual case because in most instances the tribunal in similar circumstances has said, well, we do actually look at the new planning scheme and the contents of the new planning scheme or the design and development overlay are relevant and are a factor against the amendment of the permit. But basically I think the tribunal in this case was satisfied dealing with one story and it couldn't really find anything adverse about the extra story that would merit refusal. Foster's Group is also worth having a look at. Do you know that you're a fan of Pinot Grigio? Tegallant Winery. It's a case about the Tegallant Winery. Obviously not fans of Pinot Grigio. Anyway, I just say that because the tribunal decision waxes lyrical about the wineries that Tegallant produces, so it's worth a read from that point of view. But that's, as you've probably indicated by your response, completely irrelevant. Basically, the Foster's Group, or Tegallant Winery, wanted a permit to use land as a function centre. A function centre was an existing use, a prohibited use. So they sought to amend the permit under Section 87A and sought approval for the new function centre, which was prohibited under the planning scheme. They also wanted to increase the number of patrons at their restaurant from 74 to 274. And again, the planning scheme imposed a mandatory limit of 150. The tribunal said, we can, in theory, approve the increased number of patrons at the restaurant. So we can, in theory, go above the 150 limit set out in the planning scheme, but on the planning merits, no. You don't get a planning permit because the planning scheme has been amended and really it's seeking to cap numbers at 150. It also said we can't approve a prohibited use that's not already authorised under the permit. So we can't approve a new prohibited use under Section 87A, so there are limits to the power to approve an amendment to the permit. Now, the other limit, go back to Section 72, is this transformation test. Also can't use Section 87 to approve something that would amount to a transformation, complete change to the permit. So if you have a look at the decision of Central Estate Properties and Manningham, it's an example of a transformation case. What happened there was the permit holder sought to amend a permit so that a retirement village, they had a permit for a retirement village, they sought to amend the permit to have a residential typical dwelling development approved. And the tribunal said no, that's a complete transformation, it's a totally different use. You had a retirement village approved, use as typical dwellings, apartments, is completely different and a transformation of the proposal. So that's an example of a limit. Interestingly, I have another case in about 2 months' time where a developer's trying the exact same trick. So they have a permit for a retirement village. I'm acting for the Stonnington City Council and they're applying to amend their retirement village. It's one of these vertical retirement villages, so it's about 6 stories. They're seeking to convert it to an apartment development. So of course we're going to run the argument, don't tell the other side, that it is not, well I know we're going to run this argument anyway, we're going to run the argument that the application can't be approved under Section 87A because it amounts to a transformation. Yep. So, there you go, there's a limit. Just quickly, another limit is the circumstance where there's been a previous VCAT decision or mediation. Have a look at King David School. Basically it says when there's a previous VCAT decision, it's against public policy to revisit the VCAT decision and allow an amendment which is contrary to the findings of the VCAT decision. Also, if there's a mediation reached, again, it's contrary to public policy to allow an amendment which would overturn a mediated outcome. 478 St Kilda Road effectively added a story in circumstances where there was a mediated outcome that the story would be removed, so it's an interesting case. But in that case, the original landowner and party to the mediated deal had on-sold to 478 St Kilda Road Land Proprietary Limited. So the tribunal was slightly sympathetic to the new landowner. Very interesting case, that one. So if you're in a VCAT hearing and you mediate an outcome, you have to be aware that even a mediated outcome may not be bulletproof. But generally, if there's a mediated outcome, the tribunal will be reluctant to revisit the mediated outcome. All right, so Alan's given me the wind-up, and happily we have finished. It's just a summary of various amendment processes, who can apply, scope of the amendment, and whether third-party participation rights apply.
I'd better wind up quickly, and before I thank Andrew, just 2 brief things to note. One, I'm taking Emily Killen's class this evening. I don't know if you might find that exciting or abhorrent or other descriptors. The other is that the exam date is to be published sometime tomorrow by the Central Administration. It's already up, okay. The other thing I was going to say to that was, if you haven't been at Melbourne Uni before, they are very reluctant to change that, and it is very unusual to give an alternative exam unless there's a very compelling reason. So don't bother asking. It's not me, it's them that decides. So before you head off, I'd like to acknowledge Andrew's inputs again. A lot of incredibly practical And we'll see Andrew again in 2 weeks in the summing up session we have in week 12. So thanks, guys. That was really good, Andrew. Bit of updating there. Worked out really well. Yeah, I think that's great. Yeah, fits in really well. And the thing is, these guys use this one as practice as well. Like, it's really practical, as well as what I examined. So yeah. Hi.
I have a question if you don't mind.
Sure.
Or if you can rush off.
Sure.
So if we have planning budget, especially that,
Oh yes.
we're thinking about going to a secondary concept rather than doing other stuff.
Yeah.
But we actually change the external look of the building because the initial design of the planning permit is designed for the purpose of getting permit to sell the land.
Yeah.
Now we wanted to improve the design for the marketability, right? So for
Shut this down.